Hi, everyone. It's Lisa from Been There, Got Out, and I am so excited to have our friend Ruth Chung. She's a New York City matrimonial attorney. She's been on before, and she's coming back to talk to us about how to, well, among other things, how to capture the judge's attention in court, especially if you're pro se. So, Ruth, you want to just, for people who haven't heard the last interview, just in case, can you give us a little bit about your background?
Sure. My background is I have an education, master's and bachelor's in forensic psychology. I've spent many years bartending around New York City and just interacting with the public at large. I've been an attorney now for 6 or 7 years and just practicing solely in the field of matrimonial and family law.
Yeah. And so I usually say what makes you really good at your job, but I think you already started answering that. I mean, a degree in psychology, bartending, New York City, and dealing with everyone there, like that puts you way ahead of a lot of people in this
It's
field.
been helpful. It's definitely been helpful. That's for sure.
I bet. All right. So let's get to it. So I know that we've talked in the past about often myths and myths that people have about what to expect with the legal system. And the first one is justice, immediate justice. But what realistically should people expect from the legal system when they're, thinking about what their goal should be?
I think, the thing that I tell my clients the most often is that they should have a goal. You can't just enter into the legal system sort of wandering around, seeing what will happen. It's kind of, you have to have a reason to go in there and ask for relief. There are certain required things that the court will force you to do. And so you should be educated about what those things are and sort of understand that pathway that you're going to take if you enter into court. So I usually tell people we don't go to court just because. We go to court if we have to. And usually having to relates and correlates to a legal goal of some kind, or something that requires a third party to weigh in on your situation.
Now, so you said that people should be educated, but a lot of people are the opposite. They are completely freaked out. They say, I have never done this before, and my lawyer hasn't explained anything to me. That's how they end up on our doorstep. They're just like, what do I do? Like, no one's telling me, and I don't know what to expect. So how, if someone doesn't have a lawyer or a high conflict divorce coach, like how can they educate themselves?
I mean, that's a tough question because the education really even the things that I teach my clients and inform them about are based on my experience. So there's no place where a person can just go online and start reading about exactly what's going to happen. I know that Reddit has been helpful to people, just Googling things, but to get the real understanding of the courtroom it's a very difficult thing to communicate. So just being educated, I think I would recommend folks talk to maybe other people who've been in divorce preliminarily, not ongoing, because that can also cause doubts and different things about your relationship with your lawyer. Everybody talking and telling you what you're supposed to do is not always helpful. But as a preliminary sort of interim research, just asking what their experiences were like. I think certain courtrooms and courthouses are public, so people can go down. I mean, it's not something when somebody wants to do on their day off, go check out what, the divorce, Supreme Court's going to look like. But, for the inquisitive folks who really just want to get that test run, they can head over to court and just ask a couple of questions here and there.
But pop culture is probably not the best place to get an education on what court looks like.
Certain shows, probably entertainment value is high, but there's one show that I do like, which is The Good Wife. It doesn't really touch on matrimonial and family, but she in the show, she's a civil litigator, and they take all kinds of cases. But the one valuable thing about that show, I believe, is the way that they've developed her character as someone who not only has to be a lawyer sometimes for herself and other family members, but as someone who has been traumatized by another family member. She just really is able to keep composure. They just really demonstrate that kind of position very well. So I would recommend it just even for entertainment purposes, and to learn a little bit about behavior in court.
Okay, so that's a perfect lead into the next question, which is for those of us who are pro se, or sometimes called pro per, or self-represented, which is a huge number of people, unfortunately, who have to go to court and be their own attorney, essentially. Like, what are some really important things that we should know?
I would say that first, the court, at least in New York, is not going to make final decisions on things until there's a hearing. They'll hear both sides, but coming into a court proceeding, everyone has their own side of the story, and the court doesn't know who to believe more than the other. I think credibility is a huge, it's very important. You want to present as a credible person. Well, how do you do that? You just tell the truth. But the court will decide things on based on things that are proven, not necessarily what your reality is or what the other party's reality is. I like to sort of compare it to being a part of a play. And not to say that everyone should be acting, but there's a way to sort of frame your narrative, your story, for the court in a responsible, mature manner where the court looks at you and says, oh, that person seems like they're telling the truth. I accept, I'll accept what they're saying as credible. So those, each meeting that you have with the court, the more consistent and credible that you are in each appearance, which also includes a lot, not eye rolling, not reacting to the other party's potential, mudslinging. It's just trying to understand that the court has a job. They have one job, and it's not to be your relationship coach. It's about finding out how to decide that issue that you've come to the court for. So yeah, I tell people that we're going to put on a play of your life. And, based on my advice, we should end up looking like you've done everything you can to resolve this without a lot of litigation.
Yeah. So what you said about credibility, we just got off a call recently with someone who was saying, I want to go, we were trying to figure out what the goal is. And she said, I want the judge to see that he's lying. He's lying. I was like, okay, but what do you want the judge to do about it? And then I also thought about how everything on court documents, a lot of things say if you're found guilty of perjury, you could face all kinds of penalties. But every lawyer I've talked to said the court doesn't care. They never do anything about perjury. So how important is credibility versus like catching someone in a lie?
I think it really depends. I think credibility, you don't necessarily want to change who you are or your position just based on the other person, because then you're straying from your goal. Like, you kind of have to stay focused on your goal. And yes, like, of course, the other party might do something that you don't like or say something that is untrue. And you kind of, like, my job as an attorney and what I would do if I were there is weigh whether it matters. Like, does it actually matter to the ultimate goal, to the ultimate end of the case, if we try and correct this lie? And also the idea of lying, everyone is telling a favorable tale of their experience. And even if it's not that conscious, people tell stories or they tell their side of the story in their subjective way. So it's not, what is the truth anyway? Is kind of, that's something that I confront all the time. And just as an advocate, I try to just help folks understand. We'll do our best to present the case in a responsible, credible, honest manner. And some of it the court may care about and some of it they won't. So, it would be important to some people to be heard on some of these issues. But if it can be cut, then maybe you should cut it.
Yeah. I mean, and as you're saying that, I'm thinking about all the false allegations that come up in these really dramatic cases where people, our clients sometimes say, my lawyer didn't say anything, and the other side kept saying all these lies about me. But it makes sense, because you're saying it's not, sometimes it's not worth addressing if it doesn't relate, if it's not relevant to the end goal.
Right. I mean, for certain things that if there, you know, if there's safety concerns regarding the care of children and those are being misrepresented, if there's, you know, but if someone's like, she's going out with her boyfriend every night and she doesn't have the kids, and it just doesn't matter. It doesn't matter. You're allowed to do that. Who cares? You know?
Right.
So, but that person arguably will know that the accused will feel triggered by that. And so that's kind of the point.
Right. Like, that's the strategy to get you upset.
Yes.
Okay, so let's say you're pro se, someone's pro se. Like, how can you capture the judge's attention? People who are self-represented are not lawyers most of the time. So what do they do? What are some ways that, what are some tips you have for someone like me and a bunch of people out there who, for whatever reason, don't have an attorney representing them?
Yeah, I mean, it's very difficult. It's hard to be pro se in these things. They're not designed to be, they're not easy for folks to navigate these proceedings pro se. Anything from the documents to the legal jargon to the procedure. I mean, it's just not built for that. So things that may help a court look favorable. I mean, I'm not a judge. I have never sat in that position, so it's all just my opinion. But I think that it's helpful when a party is kind of humble. They understand that the court is in charge, the judge is in charge, and any opportunity that they get to speak is not unlimited. So that goes back again to the, you know, picking and choosing what you say. It's also to be respectful and control your facial expressions. You know, if somebody's sitting in the chair and they're like leaning back, you know, sitting back without deference or respect to the court, it's probably not going to look good. I mean, so much of our communication with one another is nonverbal, and that's something that just doesn't get captured in a lot of the world, actually, but especially in court proceedings. There's so much reading of the room going on that it's just best to present as like a blank or neutral sort of affect, unless being, you know, slightly annoyed or you know, it just depends on if it works for you. But I wouldn't just go in as a raw. It's not a raw place for you to lay your head and find comfort. It's a place where you have to prepare to show somebody why you should or should not get the things that you're asking for. So it's kind of a presentation.
Yep. Now, you also, speaking of that, you said something really interesting the last time we talked about how eye rolling or making certain expressions could be considered ex parte communication to a judge, and you can get in trouble for it. Can you explain that? Because I thought it was fascinating.
Yes, it's only happened to me once, but I have it's happened to my client one time. But I've heard other discussions about this in other forums. But the judge actually called my client out because he was nodding his head in agreement with what the court was saying, and the court felt it necessary to tell my client all in front of us that he should not be doing that, because it can be perceived as ex parte communication with the court. And
What does that
for
mean? What's ex parte communication?
yeah, so in New York at least, and I'm not sure about other jurisdictions, but I would assume it'd be similar. You're not allowed to communicate with the court. No one can talk to the judge without all the parties being present. So unless the court is with just attorneys, you know, having an off the record conversation and the parties are not there, fine. Or if there's an email just between the attorneys and the judge, okay, fine. But if a party to the case is speaking to the court without any attorneys present or the other party, I mean, it's absolutely impermissible. The courts don't even like to have pro se folks writing emails to them when they're unrepresented, because unrepresented folks don't really have a lot of this, tend not to have the understanding of the discipline of, you know, writing to the court back. They don't want to have all the, you know, pro se emails going back and forth. That's not preferred. Rather do everything on the record, I would assume.
So that's making me think of something that has been happening on part of social media, where women are being encouraged to send information to the judge on their case anonymously about what their judge should be doing and things with the law. And I was asking another attorney about it, and she said that's a huge no-no. And I think it's exactly what you're talking about. It's ex parte communication, because they're writing to the judge directly and they're not sharing that information with the other side. And the judge could be influenced by it.
Right. And that's exactly the point, is to influence the judge by this writing that no one else has access to, anonymous or not. And that's how can you have an impartial jurist if you have secret messages going to them without anyone else knowing?
Yeah. I'm thinking that the lawyer that mentioned this said that you can actually get in trouble for doing that, and you could possibly be sanctioned.
I'm sure that's true. I'm sure that's
Yeah.
true. At least admonished, right? Certainly doesn't look good.
Yeah. Interesting. Okay. What about so a lot of our clients' exes, are difficult because we are high conflict divorce coaches, and they will often say, I can't believe my ex's attorney is even working with them. Like, how could they sleep at night? So why, like, what do you think about that? What do you think about people who represent perceived very high conflict personalities?
It's hard because as an attorney, and I'm a very specific kind of attorney who runs a very specific kind of business. I'm a solo practitioner, it's a little bit different than working with a firm. I think that the saying birds of a feather flock together is sort of just in general, if you imagine this just as a person, you talk to an attorney who is, saying things that they may do and you don't agree with it, you're not going to hire them, right? I mean, there's also the occasion where like maybe the attorney's not being upfront with the kind of tactics or manner in which they practice, right? There's sort of, and I get some clients who are like feel bait and switched by prior counsel on what they said, oh, we were going to settle, but then I ended up in court. I mean, the merits of that is, the relevance and merits of that, it could be just, it had to go to court. It doesn't mean that the lawyer intentionally tricked you, but there are cases where it's very clear the lawyer doesn't really care. And if the client doesn't say anything or doesn't try to change it or move to another lawyer, they're sort of agreeing with the way things are going, in my opinion. I mean, I don't want to call everybody like sleepwalking, but it's like, you have an active choice in your life. And so if you don't like the way things are going, you can change it. It might stink to get a new lawyer, but if you're not happy with it, you should change it.
Yeah. Okay. And we talked also about transcripts. I love getting the transcripts when I've done something, because during, of course, being self-represented, like, I don't remember a lot of what happened. Why is it important you think to get the transcript after hearing?
Well, even as an attorney, I value transcripts. I usually take very good notes, but I still will sometimes get transcripts. As a pro se person, I feel like every pro se person should get their transcripts, because being in court itself is very stressful. It's, you're not used to having to take notes and understand what's going on and write down what you're supposed to be doing for the next appearance, or writing down thoughts that come up during, it's a very acute multitasking moment. So getting the transcript, even if you do try to take notes, helps you to refresh your recollection, clarify your notes, and be better prepared for your presentation at the next appearance that is going to come up.
Yeah. But transcripts can be really expensive. I know.
They can be really expensive. Yes. It is definitely something that is a kind of, I would say it's a luxury because of the cost. And, but if you're not spending money on a lawyer, I think you have to try and, figure out the best way to represent yourself. And, if you're already in litigation, I wouldn't really try to cut every single cost. There's not, if you can't, otherwise it's just, there's no point. Just give up. Don't fight it. Just give up, because, if you're not doing everything you can, And I know there's some folks out there who just can't. So that's just the unfortunate thing. But I would really try to get the transcripts. It just helps you become better prepared.
Yeah, I feel like I need the transcripts, and I love rereading the transcripts. It's really fun to highlight the
Well,
transcript.
it's also fun to it's fun. It's also interesting and helpful to know that the longer the transcript is, the more it will cost. So that should help somebody think about what do they actually want to say on the record, and they don't need to, have a therapy session with the judge or have a vent or rant session with the judge about the other party because they're going to have to pay to get that printed and
Right.
dictated into a transcript. So or recorded into a transcript. So I would just if the person is planning on purchasing transcripts, minimize the length and cost of it on your side by not saying things that don't need to be said in court.
Yeah. Oh, great point. Even though I'm sure most of us aren't thinking about that at
No,
the time.
100%. Yes.
Yeah. Okay. So another thing that comes up all the time is people saying that the legal system is broken and needs to change. What are your thoughts on that?
I am not in love with the way that things go in cases, but and in court, but broken maybe. It's the problem is I think that these sort of cases, matrimonial and family law cases, really deal with highly emotional, sensitive, and very subjective sort of issues, and not many people are happy with the results, even if it's objectively a good result. Like the lawyers often will say, and courts even say, if both parties are like a little unhappy with the result, then it means it's a good settlement. So it's not a place where you're supposed to achieve happiness. And so looking at the system, is it broken just because of the amount of people that are unhappy with the results, or is it broken because it's not actually doing what it's tasked to do? It can just vary, I think, from case to case. The courts do help people sometimes, but I would love to see more psychological support, mental health awareness and support in the courtrooms. Just, things change really fast these days. I think technology has taken off on different ways to abuse folks, to blast information about things, and there's a lot of false education. Just it would be helpful to have a jurist, and some of them are, don't get me wrong, who really are in tune with the times, so to speak, on those sort of things. Maybe it wouldn't be so hard to prove emotional abuse, which is a very valid and real problem.
Yeah. I mean, what do you think about judges being forced to get educated on certain things? I know, don't judges get to choose if they want to learn about something?
I actually don't know the answer to that, and I would be very cautious even in answering that because I don't know. A lot of the courts have, the judges have a lot of prior experience in being attorneys, and it's not none of this is to discount their breadth of experience and their talents and their value on the court. The issue is just as the litigant or as the attorney representing the litigant, sometimes it feels, like certain things are kind of being left behind in an antiquated bureaucracy. And it's possible that the higher ups don't necessarily want them to be addressed. I don't know. It's not quite in the law yet. The law changes every day, so things are moving. But I think like most big systems, it goes slower than we all would like.
Yeah. But I think when we talked last time, you said there have been significant changes. Like it feels like it goes slow sometimes, but there's been significant changes. Like we talked about women in the past, and having to have a reason to get divorced in some places. In a lot of states, you don't need a reason anymore when we're seen as
Oh
property.
yeah, yeah. I mean, just thinking about the history of marriage and divorce, and just that women were once, we didn't have equal rights to things, and we were not earners, high earners of any kind, and a lot of what I see now are women who are parenting, who are primary parenting, and also the breadwinners of the family, and so the law that was applied, probably created gender neutrally, but was applied, to protect women is now can be seen as harming them, just with the growth of women in the professional realm. So, things like that do change. I don't know that any court's sitting there saying, oh, well, if it was a man, it'd be different. I mean, I think they really do try to keep things fair, but, laws as applied to certain populations can have a result that is generally undesirable. So,
Yeah.
you know,
Yeah. Yeah. It's just making me think about what, bias that everybody feels like there's a bias.
right. Like when men were the higher income earners, they're like, I have to pay for the wife who stayed home and took care of the kids. And now, I mean, I think the difference is that not all men who are not, who don't earn as much are staying home and taking care of the kids.
Mm-hmm.
Right.
Yeah.
So that kind of connection is not being that's not carried on.
Right.
Right. The lower earner also take care of the kids. That's not necessarily the case anymore.
Right. Right. Okay. And so another thing that we talked about was how one of your goals is teaching people that they don't need you.
Yeah. So usually when somebody is introduced to me or comes my way in a professional context, it's because they're having a really hard time, right? They're having difficulties with their spouse or partner, and they usually either have kids or assets that need to be split. I mean, if you think about just basic education, like whoever teaches you how to open a bank account, like they don't teach you this in school, right?
Mm-hmm.
Like just these like real life things that you need to survive, nobody teaches you. So I think when somebody comes to me, I, talk with the person, learn about their case and their story, and I try to really like help them understand that like relationships are not happily ever after. Maybe, having a partner is not helpful to you right now. Maybe you would be okay to be alone, and maybe that you can explore those themes. Like maybe you should open your own bank account instead of having a joint one. And what does that mean? Or talk to a financial advisor to talk about how to budget. Like if you've never learned that before, divorce can be very, very difficult. One of the biggest misnomers that I hear from folks I consult with, friends, anyone, clients, is when I say the checking account, was it open during the marriage while you were married? People will say yes, but it's in my name. And I go, it doesn't matter. And they go, wait, what? It doesn't matter that it's just in my name? No. The answer is no. Like in New York, it does not matter. Anything that happens from the date of the marriage to the date that the divorce papers are filed, all marital. Whether you get to keep it or not is up for discussion, right? But it is technically marital. So that is one of the biggest things that I am just shocked that people don't know on a regular basis. They are like completely shocked that just because it's in their own name, that doesn't mean it's theirs.
Well, I think it's really good for people to hear that, especially on the flip side, because a lot of people that we deal with say, well, my ex is saying that it's not mine because it's in their name. And so I'm not entitled to it. So I can't touch it. And we're like, whoa, wait a second.
Again, each state varies. Like I don't know the law in all 50 states, but at least in New York, it doesn't matter whose name it's in.
Yeah.
For it to be marital.
And
Considered
that's
for
why,
distribution.
and that comes back to that whole thing about education is like learning your rights ahead of
Learning
time.
your rights, learning the law a little bit, learning what the intent of the dissolution of divorce is. Like, what is the court trying to do? Generally, it's to be fair and equitable, and everyone gets to walk away with, things based on the facts of the marriage, right? Equitable distribution in New York, the separation of marital property is fair, not equal. Everybody errs on the side of 50-50 because to argue against that, could end up with just people saying, no, I don't agree. Great. So then you have to go to court, right? But 50-50 gives people enough bite where it's sort of like, all right, fine, 50, at least it's half, instead of the offset. But in some cases, you really do have to fight for the offset for considering the factors of the case. So.
Yeah. Well, it's really good to know. All right. So Ruth, I don't think I forgot anything, but is there anything you can think of that we wanted to talk about that we haven't hit on yet?
No, I mean, I think I just, in general, would like to share with folks that, there is an end to all of this. It's not the rest of your life. And so to try to just keep, your eye on the prize, get out if you can with as much or as little as you want or need, and just realize that the rest of your life is still ahead of you.
Yeah. Okay. So Ruth, how can people find you?
I have a website. It's www.chungfirm.com. And I also have an Instagram, and a Facebook, but they're not super active, but I do have, a website that folks can reach me.
All right, great. And you're only New York, right?
Only New York. And it's really limited to the boroughs.
Okay. 5 boroughs. All right, good. Well, thank you so much, Ruth, for coming back on.
Thanks for inviting me. It's great to see you.
You too. I'll talk to you later.
Okay. Bye-bye.
Bye.